Welcome to Working for Women, the Independent Women's Forum podcast, where we are changing the conversation about women and public policy for the better.
Hello, I'm Hadley Heath Manning, Policy Director at Independent Women's Forum, and your host for today's Working for Women podcast. Today I'm joined by IWF Legal Fellow Erin Hawley, and we're going to be discussing an upcoming Supreme Court case called Janus versus American Federation of State, County, and Municipal Workers. For municipal employees, Erin has written a legal brief for IWF on this topic, and it's available online at iwf.org for those of you who want to dig in deeper to this subject. The oral argument for the Janus case is coming up on February 26th. So I wanted to sit down and chat with Erin and get a preview of what we should expect in this very important case. So thank you, Erin, for joining us today.
Absolutely. Delighted to be here, Hadley.
So first of all, maybe just give our listeners an overview of the Janus case and what legal issues are at stake here.
For sure. So to understand sort of the real heart of the case, we have to go back about 40 years to a Supreme Court decision called Abood. And in that case, in Abood, the Supreme Court held that states may force public employees, so their own employees, to pay dues to a public union, even if they are not members of that union, and even if they disagree about the policies and politics of the union. So, for example, in this case, the plaintiff in this case suffers under just such a state law. He's a public employee. Mark Janus is a child support specialist for the state of Illinois. He is not a union member, does not want to be a union member, but the state of Illinois has forced him to subsidize union activities. He pays about 80% of the full union dues, even though he's a non-member. And Mr. Janus argues that all of the public bargaining activities that the union participates in purportedly, on his behalf, are things that he fundamentally disagrees with. Illinois is in the face of a budgetary crisis, and the union is advocating for increased pensions, increased pay, a lot of things that will impact the public budget. And Mr. Janus disagrees with all of this. But that doesn't matter. He still must pay and support the union activities and has absolutely no say in the matter if he wants to keep his job.
So I was looking for some information about this case, and I ran across a Washington Post opinion piece that actually called the Janus case the biggest labor case of the century. So I wanted to get your opinion, Erin, if that's an accurate, name for this case, the biggest labor case of the century. What would be the effect of a ruling either way for labor unions and for the employees they claim to represent? Would it really be life-changing for them?
So I think that the first part of that question is certainly true, that this is the biggest labor case of the century, or at least certainly one of the biggest labor cases of the century on two different fronts. And the first front is sort of the principal front, or the constitutional principle that is at stake. So the First Amendment protects bedrock principle, as the court recently said, that except in the rarest circumstance, no person may be compelled to subsidize speech by a third party that he or she does not wish to support. So here in America, it's sort of fundamental First Amendment law that you have a right to speak, but you also have a right not to speak and not to be forced to pay for someone else's speech with whom you disagree. But that's exactly what's happening here to Mr. Janus. So this Abood case we mentioned compels non-union members to pay for speech on a whole host of political issues about which they disagree. And this is simply inconsistent with our constitutional principles and should be reversed. So it's fundamental on that front. It's also fundamental on the practical front. Today, nearly 5 million public employees are required, again, as a condition of employment. If Mr. Janus wants to keep his job, then he has to pay these union fees. They're required to subsidize the speech of that union on matters of public policy. So this is 5 million people who are required to pay for speech in order to keep their jobs, even though they may disagree with that speech. So very important on these two fronts. And then to get sort of to the practical effects on the employees and on the unions, I think we have two very different sort of interests at stake. The first one, as I just hinted at, is sort of the constitutional interest. So for each of these employees, I think the importance of a win here for Mr. Janus really can't be overstated. It's their fundamental right not to speak and not to pay for speech with which they disagree. So very important to Mr. Janus, very important to other non-members of unions who are forced to pay for that political speech with which they may disagree. Now, the question is more complicated when it comes to public sector labor unions. They are very much challenging Mr. Janus's position here and very much arguing that ABUD should remain in place. But a loss here might not mean the disaster for public unions that they actually claim. The Supreme Court recently pointed out in a 2014 case that there are many public sector labor unions that survive in right-to-work states and also in different parts of the federal government, even though there's no sort of forced compensation or forced membership fee on these non-members. So, and this is primarily because public sector unions, in addition to being able to require non-members like Mr. Janus to sort of fork over part of their salary, they also are given the right of exclusivity. So these unions have a lot of sort of power, even aside from the sort of compelled contribution component. So I don't think it's true that the public sector unions would just disintegrate in all of the states as they currently exist without this forced contribution requirement.
Now, my next question is a tricky one because I know legal analysts don't like to hear this kind of question, but can we read any tea leaves about how the justices will rule in this case? Do you have a crystal ball, or can you tell us at least if there's any hints from other rulings or the disposition of various justices who sit on today's court? Do we know anything about what to expect? And when should we expect the ruling? This summer, I presume?
Those are all great questions. And to address the last one first, yes, definitely this summertime, sometime before the end of June. The case could come out as soon as a month after it's argued, but in a case of this nature, you're almost certain to have a dissent. So I would expect the decision sometime in June, probably toward the latter part of that month, before the court adjourns for the summer session. And as you mentioned, it's always quite risky to predict a Supreme Court opinion and no crystal ball here. But I think on this question of overruling ABUD and the question of compelled speech here, we actually have some really prescient data points. I already mentioned the 2014 case, Harris versus Quinn. And in that case, the Supreme Court actually looked at the ABUD sort of public sector union arrangement and its requirement that non-members contribute to the union, and they refused to extend that to sort of quasi-public employees. And in doing so, they actually gave no less than 6 reasons why ABUD was sort of fundamentally flawed and why it shouldn't be extended, but also why it seemed like, at least in the majority's opinion, that there were some very serious doubts about the ABUD ruling itself. And I think a couple of those grounds deserve a little bit of attention. One of them was that the ABUD court's decision rested sort of on the idea that it wasn't fair for non-members to kind of piggyback upon the negotiating and all the sorts of public bargaining that the union participated in. But the court said in response to that you have to have a really compelling reason in order to justify compelled speech, and that just seems to be lacking here. They also said that it was a big mistake to sort of not distinguish between public and private sector unions. In the public sector, the court said, if you look at all of these questions that that the unions are bargaining for, they all involve matters of public policy. They're all core issues related to the state's budget, related to how the state will handle its employees, related to the monies that will be available for other services and resources. And thus, the very nature of public sector bargaining is itself political. So these things really undermine the reasoning in ABUD. And indeed, in 2015, the Supreme Court actually granted cert on this very question, the question that's at issue in Janus, and that is, whether ABUD should be overruled. They had oral argument in that case in 2015, and it revealed a deeply skeptical court of ABUD. Justice Kennedy, frequently the swing justice, actually sort of turned the union's free rider argument on its head. He said it's not that a non-member benefits from the union's work, it's actually that the non-member is a compelled rider rather than a free rider. They're compelled to go along and subsidize this speech rather than sort of a free rider who's relying on the union's efforts. The justices, again, consistent with the Harris case, had really very little patience with the idea that collective bargaining is non-political. Chief Justice Roberts noted that the allocation of public money is always a public policy issue, and many of the other justices seem to agree. Now, after the case was argued, Justice Scalia passed away in February of that year, of 2016, and so the court split 4-4 on the question and sent it back to the lower court. So this leaves us with an open question in the current Janus case. It leaves us wondering whether Justice Gorsuch will follow in the mold of his predecessor, Justice Scalia. All indications are that he will on First Amendment questions like this one, but we don't know, of course. But I think another sort of signal as to how strong Janice's argument here is that one of the main arguments made by the unions in support of Abood is actually not about Abood at all, or about sort of the rationale for making non-members subsidize compelled speech, but rather it's a stare decisis argument. And this argument is the idea that it's better that the law be settled than it be right. So since Abood's been on the books a long time, they argue, we should just leave well enough alone. But I think the 2015 grant in Fredericks and the subsequent grant in Janus, as well as the Harris case, show that the court is really suspicious, is really skeptical of the Abood decision, and I wouldn't guess that stare decisis would be an impediment. It's never a silver bullet, especially in constitutional cases, and it looks like several justices think it's wrong enough and that the reliance issues are not strong enough that they will take up the question.
And you pronounce that term stare decisis, is that right?
That's correct, yes.
Okay, I'm putting that away for my next argument with my husband. So if there's something that's settled, even if I'm not right, yes. I'm just gonna call upon that doctor.
Yes,
is that right?
Yes, exactly.
Oh, man, I like the compelled rider analogy as well. It sort of it gives me a visual of somebody who's sort of stuck on a bus and they can't get off the bus, So
exactly, and they have to pay for the bus.
Exactly. Well,
yes,
this is really helpful background and helpful. For me, I know I learned a lot. I can think about how to frame the Janus case and the oral argument that's coming up very soon. Again, those oral arguments that take place on February 26th. And for all of our listeners, I just wanted to include a reminder that we have an excellent legal brief by Erin Hawley, our legal fellow, on IWF.org, and it's called The Janus Case, Public Union Dues. So if you want to learn more, please visit our website, download that legal brief. We'll continue to keep people updated with more content like this on the case and other important issues. And we really appreciate Erin joining us today. Thank you, Erin. And for our listeners, we appreciate you tuning in. And that's all for today's Working for Women podcast.
If you enjoyed listening to this podcast, please give it a thumbs up, share it on social media, or stop by IWF.org for similar content.